Rental agreements can be one of the most important arrangements you make. Understanding the relationship between landlords and tenants can be very helpful in determining what you include in a rental agreement. The Iowa State Bar Association has created this video to provide you with information about issues and terms regarding landlord tenant law. It is not an attempt to provide legal advice, and in fact the ISBA would encourage you to consult with your attorney regarding your rental arrangements to ensure that your rights and interests are protected. It is recommended that a written agreement be used for all transactions regarding the renting of property. In some circumstances, a written rental agreement between the landlord and tenant is not necessary if the lease will last less than a year. However, having the agreement in writing protects both the landlord and the tenant. The following are items to include in a written agreement: the term of the agreement, the rent amount, day of month when rent shall be due, amount of security deposit, name and address of the manager, a list of who pays which utilities, and any other provisions decided between the landlord and the tenant. When a tenant leases a property, typically a security deposit is required to be paid to the landlord. Security deposits cannot be greater than 2 months' rent. The landlord must keep the security deposit in a bank account separate from personal funds. When a tenant vacates the property, it is the landlord's responsibility to return the security deposit within 30 days from termination of the tenancy. If the tenant has unpaid rent or has damaged the property, the landlord may keep all or part of the security deposit, but must submit a statement specifying the exact reasons for keeping the deposit. In the case of damage done to the property, the tenant has a right to look over the property and submit the tenant's own statement of damage. It is a good idea for both the landlord and the tenant to make a list and come to an agreement on the damages to the property before the tenant moves in, so that when the tenant moves out, he or she will not be charged with these damages. If the landlord fails to return the security deposit or submit a statement to the tenant within the 30 days, the landlord forfeits all rights to the deposit. If the tenant does not give the landlord a forwarding address within 1 year of the termination of tenancy, then the tenant forfeits all rights to the deposit. It is the responsibility of the landlord to keep the property in a habitable condition. This means making any needed repairs, arranging for the removal of garbage, and making sure that all electrical, plumbing, sanitary, heating, ventilating, air conditioning, and other facilities are in good working order. If the tenant is to be responsible for the maintenance of the property, it should be so stated in the rental agreement. It is the tenant's responsibility to keep the dwelling unit as clean and safe as possible, which includes disposing of all garbage and other waste. The tenant must do all that is possible to keep appliances and other facilities in good working condition. After the rental agreement has been signed, the landlord may adopt new rules. As long as they are in writing, they apply to all tenants living on the property, and their purpose is to create a better and safer living environment. The landlord should give the tenant at least 24 hours notice of the landlord's intent to enter the tenant's dwelling unit. The exception to this rule is in the case of an emergency. The tenant must let the landlord enter the dwelling if tenant has received a fair warning that the landlord will do so, and in the case of an emergency. Communication between the landlord and tenant is very important. If the tenant wishes to use the dwelling unit for anything other than a dwelling unit, the landlord must consent. The landlord may require the tenant to notify the landlord when the tenant takes any extended absences from the dwelling. If the tenant does not pay the rent or breaches the rental agreement in any way, the landlord has the right to send notice to the tenant stating how the tenant breached the agreement. The landlord cannot terminate the agreement for at least 7 days after the tenant was served the notice. If the tenant remedies the breach within the 7 days, the agreement cannot be terminated. The landlord has the right to terminate the agreement if the tenant creates a danger to the health and safety of others. The landlord must send a written notice of termination and a notice to quit to the tenant. 3 days after serving the documents on the tenant, the landlord may take the issue to court and file suit against the tenant to recover possession of the property. This gives the tenant the opportunity to contest the matter. If the tenant abandons the dwelling unit, the landlord has the right to seek other tenants, and the first rental agreement will be terminated when the new tenants sign a new rental agreement. When the landlord gives written notice of termination and notice to quit, the documents must be served on the tenant by either personal service or by sending notice by certified or restricted certified mail. If the landlord does not fulfill the rental agreement in any way, the tenant has the right to terminate the agreement. If the tenant wishes to continue the agreement and fulfills the landlord's duties, the tenant has the right to deduct the amount spent from the rent owed to the landlord. To terminate a rental agreement, whether by the landlord or tenant, enough time should be given to the other party to terminate the agreement. If the tenancy is week to week, 10 days notice must be given for termination. At least 30 days notice is needed in a month-to-month tenancy. As was pointed out at the start of this presentation, if you have any questions about renting or leasing property, the ISBA would encourage you to consult with your attorney so that you can ensure that your rights and interests are protected. If you are uncertain of your legal rights regarding landlord tenant law, a lawyer can help you with your case. We hope this video has provided you with some helpful tips regarding issues surrounding your rental options. Thank you.